Good afternoon, everyone. I'm Larry Verbit, Chair of the Entertainment Law Section. For those of you who are not members of the BHBA, we invite you to join both the BHBA and our section to participate in our Zoom seminars. As you saw in the formal intro, there are several levels of membership, and all are welcome to join the Entertainment Law Section meetings at 8:30 on the first Wednesday morning of each month via Zoom. Before we begin the program, I'd like to advise you of several upcoming events sponsored by our section. Today's program is one of a series of three comprising what normally is our 3-hour CLE annual entertainment law section review of major issues impacting transactions, litigation, and ethical matters during the prior year. Today is our ethics program, and on February 12th, we will have our litigation panel. The transactional panel will be held at the end of February. On Saturday, February 20th, the section is presenting via Zoom an exciting program entitled International Film Financing, a Global Perspective for 2021. This will be an exciting program that with panelists from Canada, China, Dominican Republic, Ireland, Italy, and the US, with participants from all over the world. You will, of course, be receiving more on these programs in the coming weeks. Materials for this program were sent via email about an hour ago. If you did not receive them, please contact the BHBA. Later this afternoon, you will receive your CLE certificate via email. At this time, I'd like to thank and turn it over to Neville Johnson, past chair of our section, who has chaired this panel and is serving as moderator.
Hi, everybody. We have over 200 people attending, which is terrific. Yes, the materials were sent to you all. We're not going to be putting them up, but we recommend that if you have a second screen, you put them up and follow along with us. Our two panelists are Marshall Cole of the firm Nemecek-Cole. His father, John Cole, is a kind of a legend in the business for legal mal, and now his son is equally forging his way and making a big name, and he's done a fantastic job of preparing the seminar materials. Ellen Pansky is the go-to lawyer for people who have state bar problems, and keep her number in mind. I want to say a few things before I turn it over and we get into the meat of it. Number one, I've done this 12 years in a row. I've moderated this, and there are a few things that should just be said. Number one, clients are not your friend. You think they are. They're going to go to you're going to go to their weddings. You're going to go on vacation with them. You go to the bar mitzvahs. As soon as the money comes in, any lawyer could have done that. I've seen that happen way too many times. Second, if you're representing two people in the same transaction, you better be really careful. There's the story of the big director and the pretty big actor who felt, I'm getting the short shift of things, and he ended up suing the law firm, the lawyer who worked at the law firm, saying, you were forcing me to be involved in a conflict. The biggest case in the last 2 years is Johnny Depp and the Bloom Hergot firm. That firm exploded. It's over. It's got a new name right now. The big issue, one of the big issues there was they didn't have a fee agreement with Johnny Depp, and the court said, no fee agreement? You don't get to continue to have any interest in that. And there was another side aspect of that case as well, where there was an allegation of referral fees, let's call it that, in connection with a bank loan that he said he didn't need. So that was pretty ugly. So we're talking full disclosure. And this business about getting a percentage is not uncommon. Barry Hirsch is one of the most famous lawyers in Hollywood. He got basically pushed out of his firm, Jackaway Tireman, and took with him, as I understand, Francis Ford Coppola and Julia Roberts, and said, I'm taking the back fees or the percentage that's coming. They said, no, you're not. And there was a trial, and they said, you didn't got nothing in writing. The client can pay whoever the client wants to pay. Let's see. Conflict disclosures, totally important. Got to do those at all times. Always collect the money. Never trust the client. Always collect the money. And make sure you have adequate insurance. With that, I'm going to turn it over to Marshall Cole.
Afternoon, everybody. It's glad to see such great attendance, and thanks for that introduction, Neville. When we put this presentation together, we had really two important things in mind specific to this practice group. And as Neville mentioned, that is the attorney-client fee agreement. The relationship starts and finishes with that. And the other important topic we're going to discuss is conflicts of interest. And so as we work our way into forming the attorney-client relationship, we're going to talk about new clients, repeat clients, what you need to have in the document, what consent you need to get from your clients, and how that relationship can evolve over time. So obviously the best thing that you can ever have with a client is an express written retainer agreement that outlines a number of line items. It has limitations. It's very clear. It is gone through with the client, and that's the absolute best. We're going to talk then about implied and fact relationships, and as you follow along the slides, it should track just in line with that. And then with respect to attorney-client relationships, we're going to talk about a new rule, and that's 1.18, when the new professional rules of conduct came out, and it refers to prospective clients. We all get calls from prospective clients, and you need to have a full understanding of what you can discuss with them and what limitations there are and how that might impact your ability to represent that person or other individuals in the same business or business line going forward. So as we work our way into express free agreements, in the slides, there's a list of 7 rules that are applicable. We're not going to go through the rules in detail, but you certainly should review those rules. And that's Rule 1.7 and 1.9, where it discusses the identity of the clients and the opposing parties. Rule 1.2 and Rule 1.5 discusses the scope of representation, and that is absolutely essential thing to have disclosed in your retainer agreement. What you're going to do, and equally as important, what you're not going to do, because you want to have your clients have a clear understanding of the limitations of what you're going to be doing for them and what you're not going to be doing for them. Rules 1.5, 1.8, 1.15, and 5.4 discuss financial arrangements. As Neville touched upon at the beginning here, there's a number of different ways lawyers can be paid: hourly, contingent, commission-based, recurring fees. A lot of those arrangements are discussed in the rules. And again, you want to have that clearly identified in the agreement. Depending on the type of fee you're getting, you may even want to get informed written consent and advise them to seek the advice of independent counsel. Rule 1.4 discusses the responsibilities of clients and lawyers. Rule 1.4 also discusses disclaimers. That's the no guarantee provision. You should certainly look at that rule, vet some wording of a provision that you think fits best within your retainer agreement for your particular line of practice, but you certainly want to make it clear to your clients that you're not guaranteeing a particular result, you're not guaranteeing a particular outcome. Rule 1.16 discusses discharge and withdrawal. Just as important as it is to start your relationship with a clear understanding of what you're doing and what you're not doing, you want to make sure there is a clear understanding of where the finish line is, when your relationship is over, what's going to happen when that relationship ends. That's important for a number of reasons, if not from my line of work from a legal malpractice defense lawyer, is I want to have a clear understanding of where the statute of limitations starts to run on your claim, because in a legal malpractice case, that is 1 year from the time the representation ends. I can't tell you how common it is for that to be unclear, because there's continuing representation, there's emails that linger on, and where a claim should have been time barred, we're now facing difficulty getting rid of it because there was not a clear understanding of when the discharge occurred. And then dovetailing from there, Rule 1.4 discusses the conclusion of services. And so with that, I want to turn it over to Ellen Pansky, who's not only the go-to ethics attorney in the field, she's my go-to expert witness when I need someone to opine on ethics-related issues. And so I'm obviously happy to be sharing my time with her today.
Thank you. Thank you, Marshall, and thank you, Neville. It's really a pleasure being here. It's something that I enjoy every year. So let me just first reiterate a point that Marshall just mentioned, and that is the importance of having a written fee agreement. It's not an ethical duty, and so you will not see any rule of professional conduct in your slides, or if you look at the rules of professional conduct that governs a written fee agreement. Some people call it a legal services agreement or an engagement agreement. However, there is a requirement in the Business and Professions Code. And lest you are unaware of this, in California, in addition to the rules of professional conduct, we are also governed by the State Bar Act. And the State Bar Act is section 6000 et sec of the Business and Professions Code. And section 6147 and section 6148 govern respectively contingent fee agreements and other types of fee agreements for non-contingent fees, not addressing plaintiffs' medical malpractice cases, which has its own specialized statute. But if you have a contingent fee under 6147, if the fee agreement does not comply in every single respect with the requirements of that section, it is void at the option of the client. And if the client voids the agreement, you do not get your contingent fee. You will get quantum merit. You will not get your actual contractual fee. On 6148 non-contingent fee agreements, there are also specific requirements that must be met. And there are some exceptions. For example, if you're representing a corporate entity, you are exempted from having a written fee agreement. If you're providing services on an emergency basis, you're exempt. If you're providing the same services that you provided in the past to the same client under the same terms and conditions, you're exempt. But all that said, I recommend that you have the written fee agreement every single time. And part of the reason for that is that an attorney-client relationship can be established by conduct. And whether or not there is an attorney-client relationship is looked at not from the lawyer's point of view, but from the client's point of view. The standard is, what would a reasonable client conclude with respect to whether they have retained the lawyer? And so if you, and this is sort of the law school example, if you're at a cocktail party or you're walking your dog and a neighbor says to you, hey, can I pick your brain for a second, tells you what their legal issue is, and you advise them, you probably will be found to have entered into an attorney-client relationship with that individual because they've asked you for advice, you've agreed to give it, and you've given the advice. It doesn't matter that you don't have a contract. It doesn't matter that you haven't been paid. You may, in fact, be found to have established an attorney-client relationship. And if you do have that initial conversation with the prospective client, in California, the case law is quite clear that now the duty of confidentiality has attached. So now, not only do you have a duty to keep that client's information in strict confidence, but you may also be disqualified from accepting representation adverse to another client, a prospective client, in the same or in a related manner. We don't have time during this presentation to talk fully about conflicts of interest, the substantial relationship test, and so forth. But the reason that Marshall has emphasized, and I reiterate, that you should always have a written fee agreement is that one of the things you're going to have in there is a specific description of the scope of services. Please do not write the contract to say, I'm going to represent you, client, in all of your business affairs, because now you're on the hook, or at least the client may later allege that you took responsibility for everything that that client had in terms of legal issues, and that may affect your fee. If you agree to accept a flat rate fee and you agree to represent them in their business affairs, that really explodes the extent of legal services that you may have obligated yourself to perform.
Let me just interrupt. We are getting some questions. If you have questions, send it to the chat and I'll review them. One question was, what was the name of Johnny Depp's firm? It was the Bloom Hergod et al. Firm. And another question was, does it matter if you disclaim that you are not their lawyer?
I would say it is helpful if you disclaim that you're not someone's lawyer. The way that comes up frequently is in the situation where you have a client, maybe it's a longstanding client, and they want to enter into some sort of transaction or project with someone else. And the other party, the third party, does not want to pay for their own lawyer. So you are tasked with the responsibility of either papering the deal, being the scrivener, or actually representing your client in negotiations with this third party. It's crucially important that you make it clear that you are not that person's lawyer, that they are not to look to you for advice, that you will not be giving them advice, that you're only advising your own client, and equally importantly, that anything they tell you is not going to be maintained in confidence, that anything they tell you, you will be free to share with your own client.
And I think just disclaiming, if you've had a detailed conversation with someone where they have provided what they may believe would be attorney-client privileged information, merely telling them at the end of that conversation that you're not their lawyer isn't necessarily going to get you off the hook, because again, as Ellen mentioned at the outset, the court is going to look at it from the client's perspective. And so more real life examples that I think we experience with respect to the implied in fact attorney-client relationship is ongoing attorney-client relationships that you have where you're representing a client based upon a specific fee agreement, and then that individual contacts you about something completely unrelated. Because you have a relationship with that person, you're inclined to discuss the substance of it. The client probably believes there's already an attorney-client privilege because he's being represented by you in connection with other unrelated matters. But the more you have those discussions about something new and not about what you're particularly representing that client for in the past, an implied in fact attorney-client relationship can be found. And so it's really important to be clear. And as Neville pointed out, your clients are not your friends. You're only as good as your last case. And when they get paid, they turn on you. When things don't go their way, they can turn on you. And so having a casual mentality with your clients is never a good idea. And it's never going to benefit you in the long run.
All right, there's another question is, what is the authority for that it's the client's state of mind that determines whether there was an expectation of an attorney-client relationship?
Well, if whoever's asked that question, if you want to email me, pansky@panskymarkle.com, I'll track down a specific site. But the law has developed in that area. But I just want to distinguish that for you. There is a case called Zimmerman versus Zimmerman, or In Re, the Marriage of Zimmerman, which we cite frequently on the defense side, where one of the parties in a dissolution of marriage situation contacted a lawyer at a firm and had a very preliminary conversation. The firm was not retained. There was no further contact. And later, the other spouse retained the firm. The court refused to grant disqualification, finding that because the nature of the initial contact was so brief, so transigent, that did not constitute the formation of an attorney-client relationship. So it's a multi-factor test when you're looking at whether the relationship is formed. Like Marshall said, how many communications did the lawyer have with the client? What was the duration of the communication? is it likely that in that initial conversation, confidential information would have normally been imparted? So those are the type of factors that the courts are going to look at.
And in the materials, it is provided, we provided the list of factors that the court will consider, and those are outlined in California Ethics Opinion 2003-161. So you can look to that opinion to review it in detail, and it will provide more context for the various factors that the courts look to. And again, always going to be from the client's perspective. If we look at the new rule 1.18 on prospective clients, and this is where you have a conversation and you want to be certain that an attorney-client relationship is not formed. This happens to me on a routine basis because I get calls from individuals who want to sue lawyers, and I do not sue lawyers. I defend lawyers. I'm the good guy. So when they call me, the first question I always ask is, are you suing or defending? And that generally ends the conversation. But quite often someone starts talking to me very quickly, outlining facts and scenarios and circumstances that have occurred to them. They name a firm, and I try and immediately stop it from there because I'm never going to represent that person. In the entertainment business, the same thing can happen. You can have a call with a prospective client. Within 10 seconds, you know you're not going to take the case. And once you know that, you need to take serious steps to limit what you are told. Because you can send that person on your way, but what you really want to prevent is from being disqualified in the future from representing perhaps the client that you want to represent, the other side of that deal that the original prospective client called you on. And so here, I think just from a practice pointer perspective, that's what you're really looking to do, is protect your ability to represent the opposite side of that transaction, or the bigger client, or your repeat client that usually comes to you. The last thing you want to do is get too much information, then find yourself on the opposite end of a motion to disqualify, where you're left having to explain to the court that you didn't receive all this information that the client has put into declaration that you did receive. And again, every single time, the court is going to look at it from the client's perspective. They're going to give the client the benefit of the doubt, or the prospective client for that matter. They're the lay person. They don't know the rules. They're not expected to know the rules. And so you want to be careful in that arena when someone picks up the phone and calls you about a prospective matter. And did you have anything you wanted to add on that, Ellen?
Well, if we're gonna segue from that into the conflict issues, which I think do segue nicely here. Let me digress for a moment and say, for those of you who may not be aware, we got new rules of professional conduct in California effective November 1, 2018. And if you don't have it, the State Bar publishes a very handy desktop guide that has not only the new rules, but also a conversion chart, so you can cross-reference to the old rules. And some of the rules are completely new, and some of them are significantly different than they were, including the conflict of interest rule. Under the old rule, which was Rule 3-310, as you may recall, the rule made a distinction between a prospective conflict and an actual conflict. New Rule 1.7 does not make a distinction. It just talks about conflicts. And in California, the case law has developed that if you're advising or representing more than one client in a matter or in related matters, it does not matter who the clients are. It can be business partners. It can be parent and child. It can be spouses. It can be an individual and a small corporation with other shareholders. If there's more than one client, it is a conflict as far as California is concerned. And you must make a decision going in, as Marshall just said, who is your client? Who do you want to represent? And who is not your client? And when you do the conflict waiver, if you're representing multiple clients, you need to make sure you give them adequate disclosure as to what the conflict is and what it is they're waiving, and you obtain their written consent. In California, unlike the ABA model rules, it's not enough just to confirm the conflict waiver in writing. So the lawyer can't do it unilaterally. There needs to be written consent from the client confirming that they waive the conflict. And just very quickly, when you think about it, it's true. Every time you represent more than one client, even when they walk into your office with perfectly aligned goals and one cohesive story about what the facts are, things can change. Their interests can diverge. As you go through discovery or through your due diligence, if you're going to be preparing a transaction, new facts may come to light, or the situation may change. What they seem to agree on initially, they may develop disagreements about later. As I mentioned earlier, if one client and one lawyer are in a relationship, then the lawyer doesn't have to worry about sharing confidences with another person. If you've got two clients, and sometimes this is referred to as the blurt rule or the thrust upon conflict situation, it is not uncommon for one of a group of clients to say to the lawyer, well, I want you to know that I did X, Y, and Z, but I forbid you from sharing that information with other clients. Once that happens, the lawyer's on the horns of a dilemma, because now you're in a situation where you've received information, you've been instructed by one of your clients not to share it, but it's material information that would be pertinent and material to the other client in going forward with the legal matter. And generally speaking, unless you have a prospective waiver of a future conflict, which I'll talk about in a second, if there's a thrust upon conflict of that type, the lawyer may have no option but to withdraw from all representation of everyone and hold that information in confidence.
All right, let me make a point, and I have a question from someone. One is that, and happens all the time, where we represent a person who has a loan out corporation. That's a conflict. That's two clients at the same time. So be mindful of that. Second, here's the question. What if you represent two parties who are going to render services on the same project, such as an actor and director? In negotiating their deals, the financier has an aggregate number of points for the back end deal. If one client receives more points, the other receives less. Do you have to withdraw from representing one of them? And I would say no, but you have to disclose there's that possibility. Are you okay with me wanting to go ahead and do this deal? And as you all know, lawyers, clients want to go to the same lawyer because he's got power, clout, and access to his other clients. If you have anything to add.
Yeah, I agree. I think you do not have to withdraw, but what's important about that question is you better have had a conflict waiver with the actor and the director at the outset of taking on the dual relationship, because it's clear from the outset. And I think to just hammer home Ellen's point, if you're representing more than one client, you need a conflict waiver. I mean, that's the rule. Get a waiver, because they could be aligned and it can change. And you may not even know that it changes. You may not even be informed that they are no longer aligned. And just like this actor and director scenario, they don't even know that they have differences, yet it comes up. It could be a year or two into the representation, and now you're talking about back end deal points, and it's all of a sudden one's getting more than the other. And the client, the actor might come to you and say, well, wait a minute, why aren't you looking out for my interests? Why is the director getting more than me? And you don't want to be in a position of saying, oh, well, we discussed this or we didn't discuss this. You want it to be clear at the outset that you're going to represent them both, that it's potentially likely that one may get more money at the end of this deal than the other. But despite that, based upon your best judgment, it's not going to impair your ability to represent and advocate for both clients equally. And that's what's important here. If then, just to carry on with this actor and director example, if you have a recurring relationship with the director, but the actor is a new client, you are really going to have to make it very clear and be completely candid with the actor that you've represented that director in the past, that you're going to continue to represent that director in the future. And despite all of that, you can still be independent and advocate for that actor just as you will for that director. I think and if you want to look at the conflict rules, we have them in our slides. It's 1.7 through 1.12, because the scariest thing from a conflict perspective is it's the hottest cause of action or claim tied to a cause of action in a legal malpractice case that I see. Every plaintiff's legal malpractice lawyer is trying to find a conflict claim. And the reason is because it's tied to a breach of fiduciary duty claim. And once you have a breach of fiduciary duty claim, you have potentially different causation standards between negligent and intentional breach of fiduciary duty. Fee disgorgement becomes on the table, which is not something you want to be facing, even though you may get quantum merit going forward. You do not want to be in a position to have to prove up your fees, because you won't be getting that nice hourly rate you charge them. You'll probably be getting a substantially less hourly rate. So that is why I think conflicts of interest are the most important thing that a lawyer needs to be careful with at the start of their relationship and as the relationship continues.
If I could just add a couple things. So one way of addressing this is to identify at the very commencement of the relationships, who would you prefer to continue representing? Or maybe you've had this actor as a client or musician as a client for decades, and maybe you're happy to serve as the lawyer for each successive deal, even if you're representing other parties to that deal. But you know that if a disagreement occurs in the future, you want to keep your pre-existing client. So you can prepare a prospective waiver of a future conflict, and you adequately disclose to what the ALI restatement of the law calls the accommodation client. Some ethicists don't like that word, but the client who's not your primary client, and you say to that person, you agree now that if a disagreement or a divergence of interest should arise, that you waive any objection to my continuing to represent my client, the actor, even if you end up either terminating me or deciding that you want to get your own lawyer. You agree that that's not going to constitute a disqualifier and that I can continue representing my client, even if you had communicated to me during the joint relationship confidential information that I might use against you in the future. And those types of agreements have been upheld in California. The other thing I want to mention is, and I don't know if we're going to have a lot of time to get into this, but in that situation, although the rule does not require it, the rule 1.7 does not require that for a valid conflict waiver, you say in writing to the client, you have the right to independent legal counsel before you agree to waive this conflict. And by signing this, you acknowledge that you've had an adequate opportunity to obtain such legal advice as you deem necessary and appropriate. But I recommend that you have that language in your conflict waiver. It gives you an extra level of protection. And if you think going into something that there's a possibility that the interests might diverge, not that they're even likely to, but that there's a possibility that they might diverge, then I urge you to make sure you get that provision initialed. And one last thing I want to point out, even if the situation is one in which there is no reasonable likelihood that there's going to be an actual conflict in the future, and you do the disclosure and you get the waiver, if and when circumstances change, now you have a responsibility to go back to the clients and say, now the facts are different than when you first hired me. And so I'm going to make a supplemental disclosure to you about the changed circumstances, and you must get a second conflict waiver signed by both clients, because what was merely a potential conflict is now an actual conflict, and that requires you to get another written conflict waiver. And
on that point, what I often see with respect to conflict waivers and legal malclaims that are brought based upon inadequate waivers or failure to disclose are form and generic conflict waivers. If your firm has a set up garden variety conflict waiver that it includes as a matter of course in its retainer agreements, it may be okay, but it also may not be okay, because when your deposition is being taken and you are asked whether this retainer agreement is modified to address the particular conflict scenario for that particular case, and you answer no, that is not a good fact to uphold the waiver. So we have a slide where we discuss 7 items that you want to make sure you clearly put in to each of your conflict waivers, and you want to make sure that they are different and unique for each circumstance. You want to identify who the joint clients are. You want to identify that your loyalty is not going to be compromised to each of them. You want to try to the best of your ability to outline as many of the potential conflict scenarios that you can foresee. You really just want to list them out. And that does, and you, of course, at the end of that, you do not want to say this is an exhaustive list. You want to say the opposite, that this is not an exhaustive list, that there are potentially a myriad of scenarios that can come up that you as the lawyer cannot foresee at this time, but that you will also endeavor to stay on top of that waiver. And if something does come up, it's your job to make sure you address the waiver again, make a determination as to whether you need a new waiver, or make a determination as to whether you've reached a point in time where you can no longer adequately and effectively and ethically represent both clients. And I think there's oftentimes in a representation where that point in time comes and lawyers make the poor decision of saying, I can still be independent and loyal to both, when in reality, you just can't. And while it means it may have to withdraw completely, depending on the advance waiver you get, you may have to withdraw from one. But as soon as you have an understanding in your own mind that you've reached that point in time, don't ever continue without making an informed decision to protect yourself as to how you are going to proceed. And don't ever make the decision naively that it's all going to work out in the end, because it won't. Or even if it does for that one, it won't for the next one.
Can I jump in? And Neville asked us to briefly discuss the Shepard Mullen versus JM Manufacturing case. And this is a good time to do it. If you haven't read that case, I recommend that you read it because it's truly frightening. And so in a nutshell, Shepard Mullen had a longstanding relationship with the city of South Lake Tahoe in connection with their labor and employment matters. And so a Central California office of Shepard would represent South Lake Tahoe on a periodic basis on individual labor and employment claims. Meanwhile, in the LA office, Shepard was retained in a key TAM action. And at the moment when they were retained in that action, there wasn't anything active going on for them with South Lake Tahoe. So they analyzed it, determined there's no conflict here, and they accepted the LA case. However, during the litigation of the LA case, a new matter arose which Shepard accepted and represented South Lake Tahoe. South Lake Tahoe was an intervener in the key TAM action, making it an adverse party. So Shepard was concurrently representing a client against South Lake Tahoe and was representing South Lake Tahoe, although in a completely unrelated manner. Eventually, this came to light. Shepard Mullen was disqualified. JM Manufacturing, its client, owed them a couple $1 million. And rather than paying them, JM said, you were in a conflict. You didn't have us waive the conflict. We didn't waive it. You have to not only disgorge the $2 million, must not only forfeit the $2 million we still owe you, but we're going to ask that you disgorge the $1 million or so that we've already paid you. The case made it all the way to the California Supreme Court, with the underlying case courts going mostly in favor of Shepard Mullen. And the Supreme Court, in a 4-3 decision, found that there was a breach of the duty of loyalty, that when a lawyer represents clients concurrently, even in completely unrelated matters, the lawyer owes an undivided duty of loyalty, which the court had previously said in cases going back to a case called Flatt versus Superior Court. But the Supreme Court majority said, we're remanding back to the trial court to determine whether you get to keep any of your fee, and to look at when the conflict arose and what you did after the conflict. And in that determination, they said, you had yes, we acknowledge you had a generic conflict waiver in your retainer, but that is not going to suffice. It doesn't give you a pass, because once the conflict arose, you did not go back to South Lake Tahoe, you didn't declare the conflict, and you didn't get their consent. You're out of here. And if you really want to be scared, look at the dissent, because the dissent would have taken it much further. Very, very critical of the law firm not having identified the conflict, not having gotten the new waiver, and would have ruled right then that they had to forfeit their fees. So very important, as Marshall said, to make sure that you get a specific personalized conflict waiver, even if it seems clear to you at the beginning that it's not likely to ever ripen into an actual conflict.
And in my most recent jury trial that I defended, I faced the Shepard-Mullen issue head on, and the court was very critical of the firm. We did a great job in defending the case, but the biggest hurdle in that was we faced an intentional breach of fiduciary duty cause of action. And when you have that claim, the plaintiff can recover emotional distress damages, has the ability to, which is very scary from a lawyer's perspective, because you should know that any intentional claim isn't going to be covered by your insurance carrier. And in an intentional breach of fiduciary duty cause of action, it's a substantial factor causation standard. And that's a big departure from the but-for causation standard that's tied to legal malpractice claims or negligent breach of fiduciary duty claims. And even more troubling about that particular cause of action, and that's being the intentional breach claim, you just have to intend to do the act. You don't have to intend to cause specific harm. So it's not like fraud, where you have to intentionally do the act and intend to cause that particular individual harm. So the importance of that is, if you have a conflict waiver, but you intentionally decide to represent one over the other or advance the interests of one over the other, not to harm that other client, but just because you think it's beneficial to the client's interest you're advancing, that can be found to be an intentional breach because you intended to do the act. Dealing with trust accounting issues, if you move money from one account to another, you intentionally moved it. For whatever your motivation, it's irrelevant whether it was done to harm the client or not. You've got to be very careful of that cause of action. It's, again, like I said, every plaintiff's legal mal lawyer is trying to assert it because it exerts a lot of pressure on the defense. You've got uncovered claims involved. And then it obviously dovetails right back to what Ellen was saying about disgorgement being on the table and proving up your reasonable value of services to a judge who's just heard a lot of bad facts and a lot of bad conduct about how you operate. And just one last point I want to make is, depending on the size of your firm, you want to make sure you have a very solid conflict protocol set up, because obviously the Shepard-Mullen firm is a very large firm, and it's not uncommon for conflict checks to be made within your firm. And if there aren't adequate protocols set up in place, that the conflict just gets missed. And it's not a purposeful act, but it just happens. And this is certainly common amongst big firms where things fall through the cracks. And then later on down the line, they can face disqualification and, again, disgorgement, because it's going to be looked at from the client's perspective.
And to that point, you know, I started my firm in 1989. There's no way in the world that I can remember every single client that I represented back decades. And if we don't check a conflict list, which we keep religiously, then, you know, as we were discussing, you can inadvertently disqualify yourself even after you put in significant time in a case. And so, you know, for even your own self-interest, you want to make sure that you enter the names of clients and prospective clients and important witnesses, and even opposing counsel. In my case, because I mostly represent lawyers, that's important for me, so that when you do your conflict check, you can do a careful analysis before you get confidential information as to whether or not you can have a problem accepting that case. I want to segue quickly because Neville also asked us to talk a little bit about the state bar, and because Marshall just mentioned the issue of handling trust funds. In connection with writing retainer agreements, of course, you're going to address your fees and how the fees are going to be paid. You need to look at the new rules 1.5 and 1.15 because the California rules have changed. It used to be, under the old rules, you did not have a duty to put an advanced fee in a trust account, which is a departure from the way most other states handled that situation. We've always had the duty to put advances for costs in a trust account because that money's not coming to us. But now there's an obligation to put all advances of costs and fees into the client trust account and to remove them after they've been earned. Or in the case of costs, either you're going to pay the cost directly or you're going to reimburse yourself for costs that you advance for the client. Now, there's one difference that I'll very quickly mention, which is flat rate fees. There's now an acknowledgement, an express acknowledgement that lawyers are entitled to charge flat rate fees. This is not a true retainer. It's distinguished from a true retainer, which, by the way, the State Bar detests. So if you're going to do a true retainer, you might want to call somebody to make sure that you prepare that agreement properly. But if you're getting a flat rate fee and you get the client's written consent after disclosure, that ordinarily or absent consent, you, the lawyer, would be required to put that flat rate fee, if it's anything more than $1,000, into your client trust account. If the client gives you express written consent, you can put that fee directly in your general account, your operating account. You still have to make sure that you earn the fee if you are fired or you withdraw before you complete all the services that were contemplated by that flat rate fee. And here we go back to how you describe what you're contractually bound to do in your retainer agreement. If you haven't provided all those services, even though it was a flat rate fee, you might have to refund the unearned portion. So what I want to work in here is, just as Marshall mentioned a few moments ago, in a civil case, if the lawyer is found liable for a breach of fiduciary duty, it doesn't require specific intent. Likewise, in a state bar proceeding, the state bar is not required to prove specific intent. The state bar is not required to prove that the lawyer knew what the rules of professional conduct or the State Bar Act provided. All the state bar has to prove is that the lawyer acted willfully. The definition of willful is that the lawyer intended the act or omission. In other words, the lawyer was conscious. The lawyer made the decision either to act or not act. That constitutes willfulness. The state bar is not your friend. The state bar is not a trade association. It's not the Beverly Hills Bar. It's not there to help us. It's there to investigate and regulate lawyers. And if a lawyer engages in a willful breach of the rules of professional conduct or the State Bar Act, then the state bar is very interested in disciplining you. So you want to make sure before you act, if you have even the slightest question in your mind, whether you're ethically permitted to take a certain action or to refrain from taking a certain action, you need to do sufficient research and investigation. The State Bar has a hotline. It's not staffed by lawyers, but still, it's a good place to get resources.
How aggressive is the State Bar? And I know they split away from the traditional sections that it had. Can you talk generally about your feelings about whether they are really over the line in terms of investigations?
Well, what you're alluding to is, as you know, we used to have what was called an integrated bar, in which the State Bar had under its umbrella not only admissions and discipline, but sections and committees, and would present programs like this, lots of services that were intended to educate and benefit lawyers. But most of that's been stripped away. It's been stripped away because of finances, and it's also been stripped away because the State Bar now is described, and if you drive by their building on Figueroa in downtown LA, it says a judicial branch government for protection of the public. They take very seriously that it's their job to regulate lawyers and the legal profession. They have an annual, it used to be $40 million. I don't know if it's still 40 or 25, but they have millions and millions of dollars to spend every year in attorney regulation. They've gotten so, let's just call it assertive, that now not only if you want to defend yourself in a state bar disciplinary proceeding and you go to trial, you're going to probably be hit with statutory monetary costs in the $15,000 range, but they've just gotten through the legislature authority to impose monetary sanctions as well. So it's expensive, they're aggressive, and if you get a state bar letter from a state bar investigator or an inquiry letter, please take it seriously. Don't think, oh, this client, this guy's a jerk, this isn't going to go anywhere. You have to take it seriously, and you have a statutory duty to cooperate with the state bar. And
in that regard, specifically as to the expense, when you get that letter from the state bar, generally there could be anywhere from 5 to 50 areas of inquiry, along with a number of requests for production of documents. You have an obligation to comply, and it's very expensive. From an insurance perspective, most of your professional liability insurance policies will not cover that cost. You can look for specific insurance policies, and I see them, and many insurance companies offer them, where they provide a no deductible. It could be anywhere from 10 to 25. I may have even seen as high as $50,000 line items set aside for state bar investigations and state bar disciplinary actions. It's certainly something worth looking at. I don't have the cost figures offhand, but any broker can get that for you. And when you're up for renewal, it's something you may want to consider adding, because I think the level of investigations are certainly increasing. And I think and even to the extent they're not increasing, I think that what they're asking to be provided is intensive, time consuming, and it's very helpful to have that added protection, because you don't have to reach out of your pocket to pay Ellen to respond to each one of those bullet points, which takes a lot of time, because she and any other competent state bar attorney is going to take it very, very seriously and advocate on your behalf. It's a no mess around zone. And so that's just something to keep in mind when you're up for renewal. And I think the last, I know we're kind of running tight, and I know Neville wanted to discuss arbitration provisions.
Yeah, go ahead. We've got 7 minutes.
Sure. So a lot of us include arbitration provisions in our retainer agreements. In defending legal malclaims, I'm seeing a lot of challenges to those agreements on a regular basis in the Superior Court once an action is filed. You can have it in bold, you can have it underlined, you could have it on its own page, you can have them signed right below. It's not going to stop an attack. And I am seeing judges be more cautious when they look at them, be, again, very mindful of looking at it from the client's perspective. But even if it's something you want, you really need to consider the expense of arbitration, because I think depending on the service you use, the costs have astronomically gone up depending on the particular arbitrator that might get selected, to the point where it blows through your entire insurance policy once your limits start to burn. If you're underinsured, and I would classify that in the city of Los Angeles as anyone up with under $1 million, in my opinion, is underinsured. It just, given the types of business that's done here, the types of deals that you all are probably handling, if you have under $1 million, that's inadequate. And if you're in arbitration, you're likely going to show up on the first day of the arbitration with insufficient funds to cover you in the event that a plaintiff's award is found by the arbitrator. So really think heavily about the costs and benefits. We obviously all know that the big benefit is it's private. It doesn't get aired in the court of public opinion, but you got to remember that most plaintiffs are going to ignore that arbitration provision anyways, file the complaint in the Superior Court only for you to have to petition to compel the arbitration, and then it makes its way into that particular service.
And you're generally not going to want to have an attorney's fees clause for the prevailing party, because if you represent yourself, you don't get any fees, right?
That's correct. I would not recommend you representing yourself in that proceeding, but you wouldn't. And again, that's another thing to think about, whether you want to have a prevailing party fee provision. Some firms put caps on that. There's a lot of ways to go about it. I know my firm in particular does have an arbitration provision and does have a prevailing party attorney fee provision. It's something we've given a lot of thought about. It's something we routinely modify to make sure we believe it's enforceable. But it may not make sense for your business, depending on how you operate, your risk tolerance, and your publicity level in the community.
Here's a couple more questions. Is there any redress for wrongful claims to the bar by the lawyer charged?
I'm not, are you asking me? I'm not following. Can you say that again?
Somebody makes a bad claim against the lawyer. Can the lawyer do anything about it?
Oh, not at the state bar. The complainant has immunity. In civil, you have a malicious prosecution claim if you prevail.
Don't do that. That would be, you'd face a slap motion.
Let me just say, I know we're running out of time, but I just want to add a very important point regarding arbitration. We are all subject to the Mandatory Fee Arbitration Act, MFAA, which is in the B&P code at section 6200 et seq. And the Supreme Court has ruled that the MFAA takes precedence over your contractual arbitration clause. So the way it works is, even if you have an arbitration clause, the MFAA has been interpreted to mean that at the beginning of representation, no fee dispute has arisen. So that clause is not valid at that time. When the fee dispute arises, you have the absolute obligation to give the client notice of their right to seek fee arbitration under the MFAA, which is normally run by the local bar associations, including the Beverly Hills Bar, and sometimes, if good cause is shown, by the state bar instead. And then so it's mandatory for the lawyer. You don't have to stipulate that it's binding, but you do have to participate if the client compels you to do so. After you go through that process, if you have not stipulated that it's binding arbitration and you choose to appeal it, which you have the right to do, then you can invoke your contractual arbitration clause, and then you can require the client to arbitrate the dispute as opposed to going to court. So if you think you do want to arbitrate, keep in mind that it's not going to protect you against having to participate in the MFAA, but it will ultimately allow you to resolve that case by private arbitration.
All right. Somebody wants to know if there's any chance you can get a conflict protocol, what it would look like, conflict protocol tracking. Where can they get that?
Well, there's a lot of law office management software programs now that include a conflict checking provision. So if you're going to do something along the lines of a case management system, calendaring system, tickler system for statutes, that would be the perfect way of getting a conflict of interest checking system. If you don't want to go that far, you can just prepare something that's the equivalent of an Excel spreadsheet. And as I said, you just want to make sure that you have a mandatory regimented procedure in your office so that every single time you elect to take a prospective client contact, that name goes in the conflict checking system. That's the system that I started. My firm started in 1989, and it has many tens of thousands of names in it now. And even though it's relatively simple, it works very well as long as you put the information in.
We have a similar setup in our firm as well. And you also want to make sure that whatever system you use, one person needs to maintain it. And you don't want to have multiple people with their hands on it, putting names in, because that's how things get missed. It should be a specific task. It's regimented. The same thing happens every time, from the time a client call comes in to the time that client is retained and or not retained. You don't want to have different attorneys handling it different ways, because that's how certainly things are going to fall through.
Here's a final question. Is it okay to have your retainer that the client fails to pay, in your retainer, that if the client fails to pay legal fees either now or in the future, then the firm has the right to terminate the fee agreement and the attorney-client relationship immediately?
No, you can't. That's the short answer.
The short answer, and the reason being, you can't just terminate immediately. If there's a breakdown in the relationship over a fee dispute, you can't just leave the client high and dry depending on where the status of that deal is, where the status of that litigation is. It's certainly possible that it could occur if there's nothing going on in the case and they won't be prejudiced. But that's the key word, is if the client's going to be prejudiced in any way, you'll have to file a motion to withdraw, have an opportunity to be heard, they'll have an opportunity to oppose, and the court would hopefully let you out at that point in time.
All right, we have reached the end of our discussion. I really want to thank Ms. Pansky and Mr. Cole and all of you out there who were kind enough to watch this. So thanks again, and we'll see you next year.
Feel free to email or call with any questions about the presentation. I'm happy to answer, and I'm sure Ellen is as well.
Same here. Thank you so much.
Thank you.